No, that's one.
Oh.
Yeah. Hold on, let me see. No, looks like you're missing. Okay. There's some more documents you want to bring in. Okay, we have extras so we could start. Okay, all right, thanks. Good evening. Just I need this. Get this one. We'll get that one done. Yeah. No, they were all they were like for the first one. Okay. Okay. So this is yeah. Okay. So just this one too, please. Okay, all right, thank you. Okay, so we're just waiting on two more documents. Before we wait, we have a new person. So why don't y'all teach it what we learned last week? All right, so we went over module 1, and what did we discuss generally?
Law.
Law. Oh, all of that? What did we discuss in particular? And what? Okay, can someone come and draw the court system first, please? Very good.
This one is BOB staff.
Thank you.
You're welcome.
Okay, is she correct?
Yeah.
Okay, and so let's explain that structure now. Thank you very much. Let's explain that structure. So why do you say she's correct? What does that depict?
The hierarchy of the court.
Okay, the hierarchy of the courts, right? So, what else do we get from this hierarchy, this structure?
Precedents.
Okay, so what about precedents? And what is a precedent? Let's talk about that first. Okay, so how do we get precedents? In the form of what? Case law, right? In the form of cases, right? And in cases we have parties. We have, at the Supreme Court level, we would have what versus what? Plaintiff versus defendant, right? So when we have the matter that goes before the Supreme Court, and let's just say it's a labor dispute, we may have an employee versus an employer, or vice versa, right? If it's an employment matter, and if a decision is made by a Supreme Court judge, that decision, when the judge makes a decision and he declares basically he adjudicates on the matter between the parties, that essentially amounts to a precedent, right? At least it's judicial authority, and it's a precedent for any other decision that is going to follow in that court and in any lower court, right? And so a decision of the Supreme Court is binding on which courts?
Magistrates.
What about Supreme Courts?
Other Supreme Court.
Yeah, other courts in the Supreme Court, on the Supreme Court level, are they binding? Why you say no?
Judges on the scene now.
It's a persuasive precedent, because they're on the same level.
It's more or less
You can only
persuasive,
influence
yeah.
that.
Because you could have judges deciding on the same issue. They could have regard to what another judge at the same level has said, but are necessarily bound to take that decision. Right. Now, if a decision is brought to their attention, a judge may say, well, I'm bound by that decision. And then if a party has an issue with that, what can the party do?
Apply to a court.
Right, so you appeal to the Court of Appeal, right? Because a judge may say, having regard to decision made by, the learned justice and so whatever case, right? They may just make a determination, you know what, I'll follow that for these purposes. I don't have any other reason to depart from that. But if a judge feels that, he has another reason to depart from that decision, he may say in his particular actual case that he's working on, he may say, well, this is my decision regarding the issues at hand. I understand what the judge has said, giving a similar issue, but in this particular matter, I'm going to take this particular course of action, right? If the parties in that particular matter have an issue with that decision, then that party can appeal to the Court of Appeal. A decision made at the Court of Appeal is binding on which courts?
Supreme Court, I'm not.
Right, Magistrates Court.
Anything lower than the Court of Appeal.
Right. Now, what makes a decision binding? Now, what if I have a matter that deals with personal injury in one case? Is that decision necessarily completely binding on, or does it form a precedent for a decision that is just strictly based on employment matters? So let's just say you have a personal injury matter that doesn't involve any employment element in X case. Then I'm in Y case. Should someone be using that judgment, if it has nothing to do with anything we're discussing, should they would be relying on that ruling in my case?
No,
Why?
because it's not
It's
distinguishing.
No, that's a verb. Distinguishing is a verb. You do that because what? So you're on the right track.
Relevant.
because you look at the issue.
To make a complete sentence.
Okay.
What makes a precedent a precedent? Now, the fact is, right, a decision made by a higher court is binding on binding on a lower court. So that means whenever a lower court is hearing a matter that is related to the same issue, the decision that was made by the Supreme Court related to that issue is binding on the lower court, right? And that's how you get that's what makes it binding, and that's what also makes it a precedent. It's a precedent because it's already been made, right? Decision has already been made on that issue, but it becomes binding, it becomes relevant in the other proceedings because you're looking at the issue at hand. So the court, before we went through the process of, what makes a decision even a precedent, what makes it binding, we look at the ratio. The court considers the issues in conjunction with the facts, and the court makes a determination on the issues in conjunction with the facts, and the court gives a decision. That decision can be a precedent in another case in which those same issues arise. The facts may be different, because you could have employment matters that have different facts. I could have been working longer. I could have had a different position. The reason for my termination may be different. But the fundamental issue is whether or not you terminate me for cause or without cause, right? So that issue may be the same issue. So when we're making determination on the issue of whether it was terminated for cause or without cause, that decision can be relied on. And the question is, what weight do we put on that decision? Is the decision binding, or is it persuasive, right? So we have to know that. We will look at the court, we have to look at the nature of the decision that was made, and if the decision that you're relying on, in my case, has nothing to do with the issue at hand, then we distinguish it based on the facts and based on the other matters that arise that separates this case and the relevance of this case from this matter. So when you talk about distinguishing, it's a verb, it's something you're doing. And you're doing it because you understand the concept behind what is a precedent, right? And what makes a precedent relevant in another instance. And when you consider relevance, you also have to consider what weight you apply to it. And in that particular instance, you consider whether this precedent is binding or merely persuasive. So what about decisions made by courts in other jurisdictions? Courts on the same level. What about decisions that are made? Let's just say we have a case in Jamaica, and they were determining an issue. Let's just say they were basically the judge in a decision in Jamaica, in a case in Jamaica, was trying to construe a provision in an act that reads almost exactly like ours. And let's just say we have no decision in our jurisdiction where that same provision in the act has been construed. So we go to Jamaica to find a judge who's in the court on the same level as ours, right? And so we want to bring to the attention of our judge, look, someone else, another judge in another jurisdiction has considered this point, right? On the same piece of legislation, not the same legislation, but the same terms that we're discussing here. Is our judge in this jurisdiction bound by the decision of the judge in Jamaica? No. But what can happen?
They can use persuasive.
No, but what can happen? He can be persuaded by it, right? And that because the fact of the matter is the decision is not binding on him, is a persuasive, it's a persuasive precedent, and so therefore the court can have regard to it, because the court may consider a number of things. You know, the court may say the reason why it was interpreted that way is because they looked at the reason why legislation was created. It's not the same reason why it was done in our particular instance, or the circumstances in our country, they're so different, and that determines the way we ought to look at the purpose, etc., of the legislation. So the court could have regard to it, but the court would make a decision as to how persuasive this particular decision would be in our jurisdiction. Okay? But that decision starts off as just being merely persuasive.
So can he cite that in the decision?
Yeah.
To make her.
Yeah, he can say, because certainly, you know, when we make arguments, we could either make written, we make written and or oral submissions. And so when the court is making a ruling, the court tends to refer to decisions that were provided by counsel in support of their respective arguments. Sometimes the court ventures outside of the decisions that were provided by counsel, and the court does its own research and, you know, refers to other cases that the court may have read. But it's often times in our jurisdiction where you see judges citing cases from the UK, especially where our laws are the same, or where our laws haven't changed and our law came from the UK. Whatever decisions that were made, even if they were older ones, they're still applicable to the way the language in our law reads. You see? You oftentimes find in financial services, we rely on decisions that were made in other offshore jurisdictions as well, particularly because we benchmark our legislation very often, so some of our legislation read almost exactly the same. So if a decision is made by a court, for example, in Bermuda, and the language that they're considering in that court is very similar to the language in our legislation, then courts tend to have regard to it, and it's not binding on them, but they tend to follow the same type of decision and rationale. Okay? That's all we learned? No? We were here for like over 2 hours. What else we learned? dismissal.
Wrongful dismissal, I think that's correct.
What about wrongful dismissal? We talk about the purpose of law, right? We talk about, so what does law govern? Fundamentally, what does law govern?
Relationships.
Right. And tell me something that's key about relationships that you have learned recently.
They choose.
Change, that's true. That's the truth, but you won't just learn that. You always do that.
Each party has certain expectations of the other party.
And why? Why do I have,
Because of
how,
rights.
why, who gives me the right to expect anything of you?
Because of rights and,
Expect them to do something. What about statute? Just give me one word, right? Like, work with that one word, make sure it's word at you, and you make what you want to make out of it. You're welcome. I think you practice. I think it's something to, yeah.
Because of duties and.
Okay, so duties, powers, right? So that's where we're going, right? So in every relationships are based on an understanding as to an appreciation as to what one party owes the other. So that's like the basic relationships that we have, husband and wife. Let's talk about the basic expectation that we have. Who has a duty to do what? But depending on which husband and wife couple you talk to, I mean, duties should change, right? Right? Okay, but let's try another one. Let's just try another relationship. Let's try employer-employee, alright, the safest one. What type of duties would you say the employer, and before we go into what types of duties, etc., what's the difference between a duty and a right? Or duty and a power? If I have a duty to do something, is that different from me having the power to do something?
Yeah.
If I say you must do something, is that different from me saying that you may do it if you wish?
Yes.
So what's the distinction?
One is an obligation, the other one has an option.
Exactly. Very well put. So for duties, you have an obligation to do that. That's something that you must do. That's an exercise that you must fulfill, right? A function you must fulfill. If you have the power to do something, you have the ability to. You know, it's permissible for you to do it, and you have to have regard to when, like, if someone asks you to exercise your power, it's in your discretion to think as to whether or not you want to do it, but whether or not you want to do it, right? If you have a choice, you know what I mean? But if you do it, you are well within your right to do it. You are well within your power to do it, right? No one can say you acted in excess of any power. You had the ability to do it, and you also have the ability to not do it. Now, if you have the duty to do something, you don't have the power to refuse. You have the ability to refuse because, I mean, no one tying it behind you in a democratic country, but you also accept the risk of your refusal to comply with your duty, right? So your duty is your obligation. So if you have a duty to me, I have a corresponding expectation that you will fulfill that duty. And that corresponding expectation is really a right. I have a right to expect your performance of that duty, right? So if we know employers are required to pay us our full salary at the right time. So as employees, we have a right, right? We expect that payment, that full payment, at the right time. And you know how you all know you have a right, you let that person breach their duty. Then you can hear, but you're wrong for that. And they're wrong for that because you had an expectation, and it was a fair expectation, it's a reasonable expectation, that you had an expectation of the performance of that duty. Because directly attached to them performing that duty was a benefit that, inured to you. And so by them not performing that duty, you are now suffering a loss, right? So for every duty, there's a corresponding right to the expectation of the performance of that duty. Alright? And duties are obligations. Powers, they permit people to act within the scope of the power. So if I have authority to do something, it gives me the power to do it, but I also have the power to refuse it. So I have the power of refusal and the power of acceptance. Okay? Alright. Anything else we learned? So I take it that y'all didn't go to work bragging about how y'all learn about duties and powers and all that. Y'all just kept it to yourselves. Did y'all read chapter 1 with regard to, module 1? At all before you came?
Yes.
Alright, because we're not going back over it. Alright, so you're on module 2. I noticed that some of you have your Employment Act. Very good. And for those of you who don't have a copy of it in your hand, but you downloaded it or you skimmed it. Anybody does not have a copy of the Employment Act tonight, you don't have yours, eh? Anyone who was here last week does not have a copy? You don't? Okay. So have a copy next week, okay? So let's see if we can sit next to someone with a copy if you wish, or you could look on your phone, go to the Laws of the Bahamas online, and download a copy. If you have a copy of the Employment Act, that is the principal legislation. Also, there was an amendment to the Employee Act that deals with redundancy provisions. And that amendment is the Employee Amendment Act of 2017. I don't know if you all saw that. You saw that? Right, very good. And so you would notice that at section 2 it says part 6 of the Principal Act is repealed and replaced as follows. So let's quickly go to our Principal Act to see what they're talking about. So go to the Employment Act and we'll notice there's certain parts of legislation, right? We have our long title, which is this broad piece here, and it really describes the purpose of the act. Is the long title of the act. And then you have the short title that says this act may be cited as the Employment Act. So the Employment Act is really the short title. The long title is an act to establish minimum standard hours of working and vacation with pay for employees, to provide for the granted maternity and family leave, to provide for redundancy payments to employees, to make provisions related to notices to terminate contracts of employment, to make provisions relating to summary dismissal and unfair dismissal, to make provisions in respect of the employment of children and young persons, to make provisions in respect to the wages of employees, to make provisions related to fingerprinting and lie detector tests, and for connected purposes. This is a long title. But instead of saying all of that, you have a short title, the Employment Act. Underneath that, you have the definitions. So there's some words within the act that are defined specifically by this act. So they don't take their ordinary meaning, they take the meaning as defined by this act, right? If that word appears in another act, it takes a definition that is provided by that act, or there's no definition provided by that act, we take the regular denotative meaning of the word. Then, in the legislation, we also have, you see some small text on the side, they are marginal notes, just to kind of give you the concept of what those provisions mean. So you'll see on the side, application of the act, standard hours, etc. So you can look at that and get a sense of what that section is supposed to talk about. But I took you to the Employment Amendment Act to show you what was actually repealed, because it said we're repealing all of Part 6. So let's go to Part 6. Part 6 we will find on page 15. You'll see 15 to the top here, in the corner. Sorry? On the phone. Go to this one. Okay, let's keep going. We're going on page. We're going to it starts at section 26, so then bolded number 26 comes under part 6. So the Employment Amendment Act says that this act, the purpose of this amendment act is to repeal all of part 6. So that's all of that, and that's the part that is redundancy payment. So that part in this act is absolutely removed and is replaced by what's in that amendment. Okay? So if you're dealing with redundancies from, any time after now, the redundancy provisions under the Amendment Act is what applies. Okay? You don't look at the redundancy provisions in this one. Okay? So that's just to let you know what that meant. Now, so we know under this act sets the minimum standards of employee relations. And in particular, we saw the long title said, this act deals with vacation provisions, pay, maternity, notice provisions, lie detector testing, etc., right? So this is your go-to for employment relations in the Bahamas. Okay? So let's consider a typical employee dispute. I think the easiest thing for us to always remember and rely on as an example would be wrongful dismissal, right? So wrongful dismissal is what? We talked about that briefly last week, and what is wrongful dismissal? Exactly. Right? But what does sufficient notice mean? So let's start with the basic principle. As an employer, I have a right to do what?
Dismiss you at any time.
Okay, that's my right, that's my power. I could dismiss you at any time. But what's my duty in relation to that power? I have an obligation to give you proper notice or pay in lieu of that notice, right? Now, of course, if I catch you stealing from the company or you are guilty of dishonesty, then it goes to the fundamental terms of our relationship, then I don't have to give you notice. You know exactly why we can't work together, because this thing can't be sustained. And you should not be able to benefit from your wrongdoing, right? And so we call that summary dismissal. Now, if a person was dismissed or dismissal with cause, so we're talking now about a situation if someone is dismissed without cause. If I'm dismissed without cause, then although you could tell me leave, and you could give me whatever reason, you could tell me, not whatever, you can't lie to me, right? But if you tell me I just don't want to see you anymore, that's fine. But you have to pay me, right? And so the law says you have to give me reasonable notice or pay in lieu of notice. So the Employment Act sets the minimum standard of what is reasonable notice. So let's look at Section 29. Now y'all gonna get to this with your other lecturer, but I'm doing this for a particular purpose, okay? Sorry?
Is it famous section?
The famous Section 29, right? The famous. So I want someone to read Section 29, 1A. And when I say 1A, I want you to read the part that's behind the 1 in brackets and all that's under A in brackets. So let's go. Someone please read that.
For the purpose of this act, the minimum period of notice required to be given by an employer to terminate the contract of employment of an employee shall be when an employee has been employed for 6 months or more than less than 12 months, 1 week's notice or 1 week's base pay in lieu of notice, and 1 week's base pay or a part thereof on a prorated base for the said period between 6 months and 12 months.
Okay, so what they saying there? Let's summarize that. Who we talking about there?
Basically, if you don't give an employee notice, this is what you owe them. If they've worked with you for.
But which type of employee? Because all employees are
Right
different.
now, this is weekly paid.
No,
Hourly paid, sorry.
no. This thing here does not define what type of employee it is. Other than the fact that this is any type of employee who has only been there between 6 months and less than 12 months. Okay? Now, whether they're hourly, weekly, part-time, because employee is not defined. Employee is employee. Part-time, full-time, nobody cares. The employee, right? That's all that matters. Okay? Because employee is not defined as full-time worker under the Act. Okay? Because that's and so don't take my word for it. Let's look under the definition section. Right? and you read it and you tell me whether or not you think employee includes a part-time worker as well. Okay, that includes part-time, right? Employee. So employee is employee, right? Once a person's on an independent contractor, and the person on your payroll, they work for you, you're the employer, that person is your employee, right? Okay, so good. So even this person is a manager and they're working for you between 6 months and less than 12 months, that person, if they're not dismissed for cause, is entitled to receive 1 month's, one week's notice or 1 week's basic pay in lieu of notice, right? Basic pay excluding bonuses, etc., right? Your basic pay. So you're entitled to either I tell you today, by next week the same time, well, next week the same time is your last day, right? That's giving you notice. Or I tell you today you leave, but I have to give you a check for the value of that 1 week notice I should have given you. So it's almost as if, but in any way, if you were to stay, you would have gotten that pay. But since I tell you to leave, right, I'm waiving I'm waiving the opportunity for you to work during that week, and I'm saying I'm going to just give you your check instead. But you're entitled to either work for your check for that week, or I just give it to you, right? So that's what pay in lieu of notice is, right? Plus, I get 1 week's pay on a prorated basis. So that means wherever period between 6 to 12 months, if I was there for 7 months, you prorate my week's pay for 7-month period. And you keep prorating it up to the maximum I could get is 1 week if I worked, let's just say, 1 day shy of 12 months. That's the most I can get. All right? But if let's just say I was there for 6 months alone, I can get a half week's pay. Because that pay would be prorated up to the period I worked. All right? Let's read B. 2(1)B. Someone else?
Where we
Where the employee has been employed for 12 months or more, 2 weeks notice, or 2 weeks basic pay in lieu of notice, and 2 weeks basic pay or part thereof on a pro rata basis for each year up to 24 weeks.
Okay, so we have two things going on here. So what type of employee are we referring to here? Let's give the characteristics of this employee. So this employee was working for more than 12 months, right? What else?
not supervisory only.
Yeah, so this is also an employee who is a non-supervisorial employee, a non-managerial employee. Okay? And so in this particular instance, this goes up by 1. So that employee gets 2 weeks notice or pay plus 2 weeks basic pay, right? For each year. Up to 24 weeks. Now what does that mean? So you get 2 weeks pay for each year up to 24 weeks, right? So how many times 2 goes into 24? 2 goes into 24 twice? 12, right? 2 goes into 24 12 times. Because 12, yeah, sorry, 12. So 24 divided by 2 is 12, right? So that means the maximum pay you could get is a person who has been working for 12 years. Because it's the cap for this part is up to 24 weeks. Because you get 2 weeks for each year up to 24 weeks. This is how you count it. So let's just say each stroke represents a year, right? I put 14 there, right? And for each year, we know we get 2 weeks, right? So we count 2 weeks, so we get 2 weeks for each year. So that's 2, 4, 6, 8, 10, 12, 14, 16, 18, 20, 22, 24. So that's the maximum we could get. If you work for 13 years, then you don't get anything for 13. If you work for 14 years, you know, thank you for your service. But the maximum you could get is right here, up to 12 years. Okay? And the equivalent of that is 6 months' pay, because you're getting half of your pay. You're only getting 2 weeks. So this works out to the equivalent of 6 months. It's a max. So the maximum you could get if you are not a manager or supervisor would be 6 months' pay, but you would have had to work for up to 12 years to get that 6 month maximum. Now, if you worked for 3 years, you just get how much? 6 weeks pay, right? Plus, of course, your notice period or your pay in lieu of notice,
So about 2 months.
right? So that's different from vacation pay. So this is just your wrongful dismissal payment, and then you deal with your vacation separately, because no one should be adding your vacation pay under this, right? So this is just strictly based on years of service, your level of employment, and yeah, okay? So we follow that? So you work for 20 years in the company and they let you go, because they tired of seeing you, and you give them everything, all your guts, sweat, tears, and they let you go because you're too slow now. You're too slow for us, and you never learn the computer, and you just get up to 12 years. But that's the thing, the employment access the minimum. Remember last week I told you about the common law. You could, and I told you about the Cambridge against RBC case. It said you could look at a number of factors. So you, as an employee, could elect whether you want the minimum standard of the Employment Act, or whether there's some other greater benefit that you could rely on. And in some instances, and in some cases, and you're going to learn this later on with the other lecturer, you could prove that given the circumstances, my unique circumstances, I'm entitled to much more than I would have gotten, which is much more, I'm entitled to much more notice than I would have gotten under the Employment Act, because maybe I'm too old now to go into the labor market and find something comparable, right? Given the nature of my work, I can't find something comparable. You look at years of experience, you look at a number of characteristics, and your lecturer's going to take you through those. And then when you add those up and you look at comparable cases and you realize that people with similar circumstances probably got notice periods of 12 months or 11 months, and the most you could get, because even though you were there for 20 years, they never made you manager, because they say it's only 5 of us who work in here anyway, you only could be one manager. And so instead of walking away with 6 months pay after 20 years, you may realize under the common law you could walk away with a year's pay, right? But you have to be able to prove that to the court. And if you can't prove to the court that you could walk away with 12 months pay, then the court is going to apply the minimum standard. Okay? Alrighty. Or something between there, because the court may say, I'm not convinced of 12 months, but I think I'm convinced of 10. But if the court isn't convinced of any of that, and the court say, well, the best you could do is really what the Employment Act gives you, then you would get your 6 if you've been working for a longer period. All right, so let's read C. Someone else.
Where the employee holds a supervisory or managerial position, 1 month's notice or 1 month's basic pay in lieu of notice, and 1 month's basic pay or a part thereof on a prorated basis for each year up to 48 weeks.
So it's the same kind of thing we did with our strokes, right? And because you get 1 month's pay for each year up to 48 weeks, it essentially equates to 12 months. So as long as you've been working there for 12 years, up to 12 years, you get a maximum of 1 year's pay. Anything short of that, of course, you calculate it by the number of years you've been working by the month. And if it's more than that, then we know the cap is 1 year. Okay? Something I want to bring to your attention though, during that notice, you see under each calculation, you have either 1 week's notice or pay in lieu of notice, 2 weeks notice or pay in lieu of notice, or 1 month's notice or pay in lieu of notice, in addition to another type of payment based on the end of service, right? That notice pay, that's the only pay that they deduct national insurance from. Okay? You don't deduct national insurance from the payment for each year of service up to 48 years. Because you done work the 48, you done work them years, national insurance already come on that. Okay? It's just that notice period you deduct it from, because that's basically the period that you could have been working, right? So you deduct only for that period. It'll be wrong, inequitable to deduct again for a period of years that you have already worked when you've already paid national insurance on it for those years. Okay? So I'm sure you do that now in HR, but that's the rationale behind it. Okay. So I brought you there because we now know that if an employer terminates you and they don't give you notice, they don't tell you, okay, next week I got a check for you and that's your last day, or next month or whatever, they just say you leave, and if you want to sue us, we don't care, right? We're a company, you're a small man, we'll blow you underwater, whatever they say. People say all kind of things, right? And so if you have a dispute with your company, we know that in that situation, if they didn't terminate you for cause, it's a wrongful dismissal, right? In addition to your wrongful dismissal, you could claim for breach of contract because they didn't pay you your vacation or anything else that was due, right? So when you have that kind of dispute, where does it start? What do? You don't just sit home and complain about it. You want your money. Because sometimes it's difficult to find a job right away. Firstly, you got to get over the fact that you get terminated. That takes a minute, right? That takes some time. Because you're embarrassed. Sometimes everything, what you know about yourself is so tied. Like how you feel about yourself sometimes is tied to the fact that you are employed, what you do for a living, the money you make to provide for your family. Like I don't think we may realize how bad it may feel to be terminated unless you really terminate, when you think that your livelihood is just gone, just like that. Especially when you feel like you've invested so much time into an institution, right? So it'll take you some time to catch yourself. After you catch yourself, you want your money. You probably mad by this time. At first you just confused, you shocked. And then you get hurt. Then you get vexed. Because you tell enough people that, everybody have a friend who is so protective, and by the time they hear that story, you're so vexed, you won't go to that job, and you just lay it on everybody, right? And so you're upset now, and you want to be vindicated because you know they had a duty that they owed to you, and you have a right to the performance of that duty, and that meant that they were to pay you. They didn't pay you. So where does your dispute start? So you can go to the labor board. Everybody says, I'm going to the labor board for you, right? And so how do you you go to labor board, so you can walk down there and go to labor board. But how do you start the process?
To find a writ.
No, a writ is in Supreme Court. right? And it's cheaper and easier to go labor board because you don't have to pay, right? That's the best thing. Because you could go straight to the Supreme Court and you have the money to do that. Because to go to the Supreme Court, you got an instructor lawyer, you have to pay a consultation fee first, right? They can listen, they can talk to you, hear what your issue is about, tell you what documents you have to bring, so write up the engagement letter, tell you how much the service is going to cost. We're going to charge you on an hourly basis. This is my hourly rate. This is a retainer for this. This is how much it costs to file the writ. By the time, depending on what your situation is, that might be too expensive a route for you to start with. So it's always good to start at the labor board too. I shouldn't say always. It's usually good to start there because you go through a conciliation process where you sit before someone who serves as a mediator and they hear both sides and they try to assist you with coming to some kind of resolution if one is possible, right? But how do you start the process? I think someone said filing a trade dispute form. So I gave you one. It's the one that has the code of arms at the top, Ministry of Labor and National Insurance Report of a Trade Dispute. And the Industrial Relations Act defines what a trade dispute is, right? So the issue that we're talking about is this wrongful dismissal. That's a trade dispute. That's an issue that's outstanding between employer and employee arising on the employment relationship, right? So you go down to labor, they're going to give you this form and they're going to tell you complete this. When you complete this form, they're going to prepare a notice of referral of a trade dispute to conciliation, and they're going to serve a copy of that on the person you name as your employer, right? So the employer is going, after you fill this out and you submit this and they sign off on it, they're going to prepare a form, send to the employer, and the employer knows exactly when you have to come down to the labor department to attend before a conciliator, right? So that'll be the next time you get to sit in a room with your employer or your employer's representative to talk about this issue. So the first step is to file this. The next step is to just wait to receive notice of the date that you go before the conciliator, right? Now that could take a number of times, right? Because when you go to the first time, everybody vent in. And you probably ain't even talking straight. It's the first time you're in front of your bosses, then when they terminate you, everything coming out, even things that are relevant. Because remember that time when they do this and whatever, you know, people start doing all kind of stuff. That's why it's good to go with someone who's neutral, who could kind of assist you with, you know, kind of formulating and focus, right? But you go there and you're sitting down. The conciliator's job is to be impartial and to just try to see if we can resolve, if not all, some of the issues. Because there may be a number of outstanding issues between the parties. And if that's not successful the first day, she may say, you know what, or he, come back another day and let's try this again. The other day may be a better day. You may be able to deal with one issue, resolve that, but you may have a few outstanding. Or you may not be able to resolve any, or you may be able to resolve all. In the event that you aren't able to resolve all or none, then you probably go again, nothing's still happening, and so then the matter is referred to the tribunal. Okay? And so the labor department will prepare a certificate saying basically refer this matter to the tribunal. Now, you could do one or two things as an applicant and the person who is lodging the complaint. You could determine, you know what, I don't want to be bothered by it, and you could just leave it there. Or you can make an application to the tribunal. You go to the tribunal, pick up one of their forms, and you fill out the application, and you express your intention to have this matter heard in the tribunal. So that's like at Form A. I gave you some documents that were attached by paper clips. So within 14, I think I call it a certificate of referral, it's a notice or a referral. So within 14 days after receiving a notice of referral from the labor department, you have to file this Form A in the tribunal. Okay?
14 days.
Yeah, 14 days after you got your notice referral from the labor department. So it's like a Form A. What all Form A asking us for? Look through it. this is the document that sets out your claim, right? So I should be able to look at this and get a sense of who you're complaining about, what is the issue between you all, what is it you want from this court, right? And you must set it out with sufficient details that anyone who picks it up, that they're actually the respondent, your employer, let's just say is an employee, bringing action against the employer. The employer should look at this and understand the totality of the claim against it, him, or her, right? And so that they can sufficiently prepare a defense to your claim. So you should prepare and list your entire claim in here, and that's the claim that you started with at the labor board, and you list it here and you provide all the details, because this forms the basis of your claim. When the tribunal is looking at the documents that are relevant to the dispute, this is one of the documents that they have regard to. This is your claim. So if you do this without instructing a lawyer, by the time the lawyer comes in, the lawyer's already, if the lawyer's received, once you get a copy of this is your claim. We stuck to this. Okay, so you have to really be specific as to what you're claiming and lay everything out the best way you can. Okay? Let's look at Form B. Now when you lay out your claim, right, this document is filed in the tribunal. You don't serve it on the other side. The tribunal takes it, they file it, and it goes before one of the judges, right? And they could look at it and say, you know what, we may need a little bit more particulars. Because, at the end of the day, you're a layman, and you may not know the best way to set out your case. So this Form B is what the court may serve on you, asking you to be a little bit more specific and to be a little bit more clear on what it is you want. And they say exactly what the issue is and what they need you to do, right? Once you provide your response to that, they will serve a copy of your Form A, right? And your answers to their requests from Form B, along with Form C on the employer. So the employer will receive a copy of your originating application, that's Form A. The employer will receive a copy of your response to the tribunal's request, if they made a request, because it doesn't always happen. If they made a request, you get your response, because together, your response and your original claim now amounts to your claim. So your clarification of what it is you want, or the details, the further details they sought and you provided, together with your original claim would now be your entire claim. So the employer will get a copy of both of those, along with the Form C, which is a notice that a originating application has been filed that includes a claim against you. Okay, employer. That's clear? So you don't have to, you don't have to serve any of those documents. The tribunal will do that for you. Okay? And that's why you have to give the details of your employer and the address, etc., because they would use that information to serve. Okay? Now, Form D is a notice of appearance. So, within 7 days after receiving a copy of the originating application, all those documents from the tribunal, your employer has to complete this Form B, the notice of appearance, and have that filed in the tribunal. The secretary sends a copy of that filed document to the employee. Okay, so the employer doesn't have to look for you and serve this on you. No, the secretary will give you a copy of it. Now, if the employer didn't enter an appearance, if you don't enter this document, that means you can't participate in the proceedings, unless either you are called as a witness. The proceedings will still go on, but you only could participate if you call as a witness, or you ask for an extension of time to put in an appearance, or if you're saying to the court, you know what, I need further particulars from this party. So the court may have asked for it, but you may say, you know what, it's not clear to us what she wants or what he wants. Before we enter an appearance, we want an extension of time so that we could get some particulars from the applicant. Okay? And we notice in Supreme Court it's plaintiff, defendant, but here it's applicant, respondent. Okay? So this document is filed. Now, within 14 days after the employer actually fills out that notice of appearance, they must file a defense. And what is a defense?
Yeah, side of the story.
This is my side of the story. So I tell you, she say, but this is our position. So what could a defense to the a claim for wrongful dismissal be? Remember now, our claim for wrongful dismissal is that you dismissed me without cause and you didn't give me my money. Now, what could a possible defense be? A defense is more than a response, right? Because a response is not really a defense. You could answer my question, but you ain't meeting me where I'm at. You're not addressing the issues that I raise. You're talking, but you're not dealing with the issues. So if I have a claim against you, your defense has to be sufficient to neutralize my claim, to almost eliminate my claim. That's the purpose of a defense. So if my defense is my claim is one of wrongful dismissal, your defense has to be one that either you gave me the money, right? And I gave you cash and you took it, and now you're lying saying I pay you, or I terminated you for cause, and I wasn't gonna tell nobody you steal that money. But now you bring this up, now you say that you stole the money. And the thing about it is they can just make it up now. Oh, okay, you steal that money? Didn't you steal that money? Yeah, you think you steal that money? You didn't go on the sign and say you steal that money? Yeah. Well, let's together we say you steal that money. So now we don't pay anything because you stole that money. So whatever it is, it could either be truthful, their defense, or it could be untruthful. It happens all the time. I shouldn't say it happens all the time, it happens, right? But a defense should be sufficient to neutralize your claim. So they have to basically establish that there's no issue of wrongful dismissal, there's something else here at play. So either I paid you and it wasn't recorded somewhere and I could bring proof that you got the cash or something else, or like you say, it's a summary dismissal. Or you owed the company money and we told you that we were going to offset it against it. And you agreed to that, right? Because you shouldn't do that. You shouldn't offset a debt from an employer with any monies you owe them, unless it's agreed, right? Unless it's agreed. But the person, you may say, but she agreed to that, right? So it's a number of things. There are a number of iterations that could come up. Now, whether your defense is a viable one is a different issue. That's for the court to decide. Okay? So that's where in this document, Form E, is where this person the employer would outline the defense to the claim that was raised in the originating application. So those two documents, the originating application and the defense, when anyone looks at them, they get a sense of the story on each side. And I get a sense of what type of facts are going to be led by both parties, because the facts are now going to have to substantiate the claim made by the employee and the defense raised by the employer. Okay. And then, so this is a notice, notice for the better particular. So the court, like I said before, we were talking about if I need more particulars, this is when the respondent could say I need more particulars from the applicant. Form G, I have a situation like this now where the hotel, one of my clients was terminated by a hotel. We have a number of issues, and it comes down to he say, she say, and it's very difficult sometimes to prove that an institution, a person from an institution, is telling untruths. But it just so happens that we are aware of someone who would have known of the untruth. So we have to hope, because we asked the person before would you come as a witness and they don't want to. So now we're going to try to compel them to be a witness, to tell us what you said to us before. That could go either way. It's risky because the person can come on the stand and lie. But it's just based on the questions that we ask them to either show that the person is telling the truth on the stand or not telling the truth on the stand. So a Form G is what I had to use to compel that person to come to court and produce whatever information. Like if there's a document they rely on to tell me certain things before that made me satisfied that this is evidence that I need in support of the case, I'll ask the court to compel that person to come to court along with those documents so that the person could be examined. Okay? So that's the purpose of Form G. So here, notice of interrogatories. This is just questions that you're asking of the other side. So we apply to the court to ask the person specific questions, and these issues may arise based on certain things that happen throughout the proceedings. Like, so it doesn't necessarily have to arise at the first instance when we receive the originating application. Sorry, I may have already seen your skeleton arguments, or I may have seen your witness statements already, and I feel like I need to get more information from you in light of certain things that were said before we get to the trial. Okay? Because that could really dispose. Sometimes you're looking at some matters and you realize, you know what? Depending on how this is answered, we don't need to go to court. Because, you know, by the time people say certain things, you look at the documents, it's like, this, your case is weak, or, you know, it's either your case, my case is weak, and like the circumstances, now I realize the quote unquote truth or the circumstances, and it may be difficult to basically prove the case that the client is telling you is the truth, right? And so, in light of certain things, you may have to make another decision. You may have to try and settle. Well, I know what you're saying is not completely the truth, but I know we can't prove certain things. You don't tell the people that, but you try to say, let's just see how best we can resolve this. Let's try a middle ground. Let's see if we can at least settle, right? And so that's the purpose of interrogatories as well. It could serve as a basis for you to get more information or clearer information to assist with your case when it goes to trial, or you could use it to kind of get a determination as to where we're at and to make an assessment as to where you need to go. Okay? But what I want to show you is the Form J. This Form J, the tribunal tends to use this form in two instances. After the defense has been filed, and let's just say there are no requests for further by the particulars, then there's no request for interrogatories, like we saw in that document. It was a simple case where we had an originating application, you have the notice of appearance, then the court serves that on the respondent. The respondent enters an appearance, and then the respondent enters a defense. Then the tribunal will issue a Form J. And they use this form for dual purposes. The first time they use the form is when you go down for the case management conference. The purpose of the case management conference, and they would say in it, for case management, after the notice, there's a notice hereby given that the application of so and so and so has been listed for case management conference by the tribunal. That's what it says in the first instance. Here on this form it says hearing. When this form first comes to you, it says case management conference. The purpose of that case management conference is that you go before, well, the president of the tribunal now these days, but you go before a judge who is typically the president of the tribunal, and you're supposed to try to set up a timetable of preparing for the hearing, and that includes agreeing on the date that we would exchange witness statements. So that means every witness I'm intending to rely on, I interview them, I get a statement from them, we reduce it in writing, we produce whatever evidence they intend to rely on. Each side does that, we exchange them. We also prepare our legal submissions on the points, we exchange them. When we're done with all of that, the court will then send us a Form J again, telling us what's the date for the trial. You don't know the trial date at the case management, you just set the dates in preparation for trial, which is what I said, exchange of documents, etc. Right? But yeah, so after that's done and you do everything you're supposed to do, the court will look at the file, see that everybody did what they were supposed to do, and then set a date for hearing, and then you get another Form J. And that's the notice of the actual hearing of the application, which is a trial. Okay? Now, the president of the tribunal, she tries to get you to settle. Like really tries to get you to settle. So it takes very long, but she's like almost like forcing you to settle. Like she sends people in the room and try to get you to settle, you know? It very rarely happens that people settle. And sometimes have to go away and come back. But I tell you, by the time you get there, you're supposed to realize that these parties aren't settling. But it's almost like I wouldn't say forced, but you feel like, okay, we doing this thing, we really doing this, to kind of go through the process. Because really at the time, you really have opposing views. The fact that someone has it in defense and no one has, and I haven't withdrawn my claim, means that we join issue on the facts of this case, right? On the legal points on this case. So after you're done with that, like I said, you get another Form K, and then you prepare for trial. Now, let's look at Form K. Form K is what the applicant could file if the applicant decides, you know what, I don't want to proceed with this. And you could determine that for a number of reasons. You could consider that your case is weak. You could change your mind, whatever reason. But once you want to stop the case, you have to file a notice of withdrawal pursuant to Form K. And so, I mean, we could basically, remember earlier I was talking about notice of application for extension of time. That's Form L. If you want to join another party, a situation where that might arise may be, let's just say, you have, some companies, they contract certain things out to other companies. Or let's just say a company may have changed, so today it may be company whatever, and they sold their business to another company, and you might have an issue as to which company really terminated the employee. Then you may have a situation where you may want to join the other company as a party, and that's the case, then you would file a notice of joining the party. Okay? Yeah, so that's a snapshot of the forms, right? So it's good to know you're on HR. Some of these forms can come right before y'all if you have a disgruntled employee. So at least you know, and these forms were found in the back of the Industrial Relations Tribunal Rules 2010. That's where we got these forms from. So at least you have a quick reference to them. When you look at these forms, you get a sense of what information they require from you and the purpose. So I have an activity for you. Also, the other paper you got was the trade dispute process, which we discussed earlier. Okay, so that's just for your reference. So what we just did is we kind of went through, for the most part, Module 2. The powers of the tribunal are also a part of Module 2. And you would know that fundamentally the tribunal hears trade disputes, and they have certain powers regarding the disputes that come before it. And on the first page of the module, they set out the scope of the powers, but the tribunal hears determines matters, and by determining matters, making a decision based on the issues that arise. In the tribunal, the trials are not as rigid as trials in the Supreme Court. The rules and all rules of evidence don't apply. So before I was saying to you that lawyers don't have to represent parties in the tribunal. You could get your labor rep, a friend, whomever to represent you. So that's why the rules are relaxed. To take into consideration that representatives from any background will, present in the court. Okay. So, did I give you all the question? No, I didn't, right? So I have work to do. How many of us? 2, 6, 4, 5, 6, 7, 8. Okay, good. 8, 4, 4. Yeah. Let's have 2 teams. We're working teams. Let's look at question 1. Beautiful. Let's look at question 1. Can someone read it for me, please?
My friend Brenda Wong is employed by ABC Company Limited as a manager in the corporate department. She is usually paid a salary of $4,000, excluding an ID contribution of $100. The last Thursday in each month,
However, she did not receive a salary last month. In response to her queries on one, when she could expect to receive last month's salary, and two, whether she could expect to receive a salary for February 2019. The HR manager
Let's
said.
let's just say this is May. Okay?
Mhm.
Let's replace February with May. So basically she's saying, I ain't getting none last month. Will I get one this month? Okay, go ahead.
The excuse me. The HR manager said, girl, you lucky we let you in these stores. People have been complaining about your braggalicious behavior. Ever since your husband bought you the big time car, you act like you better than people. Wow. Brenda is upset because after giving the company 10 years of her life, since January 2019, she did not expect to be treated this way, especially since she has not been bragging about her new car. She also expected
That's supposed to be January 2009.
Okay.
Sorry about that.
She also expected that she would be paid for the 2 weeks vacation that he earned, that she earned, but was unable to take because of the CEO needed her in the office. Brenda wishes to file a trade dispute. Advise her of the process and assist her by completing the relevant form.
Now someone read part 1 and question 2. Thank you for that.
Assume that you are the ABC Company Limited representative for employment matters, that the dispute between Brenda and the ABC Company was unresolved, and that last week, Thursday, the dispute was referred to the tribunal for determination. Prepare a memorandum to the CEO, John Paul, advising of the procedure that he could expect to be followed and the documents that the company may receive and and may be required to complete.
Yes, let's delete that out. Sorry, because I don't know what's going on with me. Okay, good. So I want you to do both of them.
Oh, sorry. Assume part 2.
No.
Oh,
No. You good. So
Mm.
part 1 and question 2 and question 1, I want you to do those. Okay? So essentially in the question 1, you'd be advising of the process, right? And then you'd be assisting her with completing the relevant form. And you should have the relevant form. Question 2, part 1, let's assume we went through the process of the trade dispute. The matter has been referred to the tribunal. You want to advise the company, so now you're acting as you representing the company, no longer Brenda's friend. Advise the CEO of the procedure he could expect to be followed and the documents that the company may receive and may be required to complete. So in addition to the documents that Brenda may serve on them, that may be served on them on behalf of Brenda, also advise him of the documents that the company may have to prepare and serve. Okay? So I want y'all to discuss that, and then you present to Brenda, your friend, and then you present to the boss. Do you want to take like one side takes question 1, the other side takes question 2, part 1? Want to do that? So which side wants question 1? I want question 1? Okay, question 1, question 2, part 1.
Get closer.
Which part two?
Question two, part
Question two, part
one.
two.
Part
Question two,
one.
part one.
That's this, right? No. Oh, question two, part one.
Hmm?
Which one are questions we have?
Question two, part one.
Question two, part one. Oh,
So you have to still look at the facts in question one. I'll get privacy.
so we assume you are a music company for employment matters. Dispute between Vernon and ABC was unresolved. And what
I'm in class right now. I'm in class.
The tribunal may ask for 4 years to provide
So they ask us what to see, what to see.
We have to advise
So we have
what
to.
forms to be coming
Okay,
in this dispute.
so it's Form C,
Form C
with
is the
Form,
first one.
along with Form A.
Along with Form C is for Brenda. Brenda is going to complete Form A.
Yeah, Brenda's gonna be on
After
Form
she completes Form A,
C.
the industrial tribunal will send Form C to the company, along with Form D, which lets them know that they have to pay.
Yeah, cause the employee have to complete Form A. But I have here in my notes. I have.
And E for the family, yes.
Yeah, I wrote this, I must have said, I have, employee receive Form C along with A, and your response B if there is a response warranted. Anyway, so let's just do this. Cause we know A, she sends this to them, and she put it in. And they
The
receive
tribunal
one.
will send ABC company Form C and D. And E is what ABC company will prepare for their defense. The memo.
Let's go. the question is, in Form F, right? Form F is any event that there is additional information that's needed, right?
Form F. First and better, but that would be determined by the so then would even be assuming they may not be.
They might not get that far.
Right, might not be.
We just said, we don't know what to
Those that
expect.
will be coming.
Yeah.
In the first instance, we know those based on what she makes an hearing and what happens when they
Then we
Form
get,
A and R, Form C, D, and E. They may say, okay, we need more information, and that's when they'll pick these up.
So basically, C and E.
CD in the first instance.
I would think so.
They would give one to her, one to the company.
yeah, if warranted.
If warranted, so we could add that if needed, form.
But I'm thinking we could just stop to the,
We can start with
right
form
there.
C, D, and E.
Yeah, because the person says, advise them on what to expect. You know, the others come along after,
After
so,
the-
after.
She could still say in the event of this happens, then expect for
Form F may be required. May be required. Or may come. It's the tribunal for it.
She gonna be lots.
If you remember, you read a memo to the source.
That's what I said.
And you're also, so if you leave that part out, you think, okay, so then you fine. Here comes F, F, why the things out? Because the tribunal is not, how are you?
The question is, so what they doing there?
They don't mind, they don't hate, they don't want. They don't want.
Oh, she said we can reserve.
Form J. Form J says notice of hearing. Is that something that we should expect?
That's if they make it, if they make it to
If they make
the hearing.
yeah, Form J.
If they make it to the hearing.
So for the other words, if it's not settled,
If it's not settled, then it goes to Form J. Mhm.
Sorry, do we need additional time? When we go to that. When we go to, this is
just say, just as an instance, your company is ABC, and they just sold the company to DEF or something like that. Yeah, and then we're trying to figure out which one they can change. But then you would have filed it under the old name.
Which one?
Oh, which one you really should be.
So,
Yeah.
you join.
So doing the two together,
So you have ABC company and
the other
DEF.
one, yeah.
So you wouldn't get into
So when she was in the children, talk like this, you tell me more.
It's found. At some point.
Yeah, she got it. That's the way I talk to you. So, I'm clean. So we're trying to do brand new. Here's what we can expect. I guess, what you
You have to.
when you say the form, you can say which form it is.
This is pretty straightforward. That goes to
Let's get the names.
I need that one. Huh? I need that one.
I need a one. I used to come in there and I used to come my man she ain't on me. Yeah.
If you know them Monday.
Yeah.
I know one.
She has a second baby.
Oh, okay, okay.
Okay, so I need Kayla.
Oh, Kayla.
She's on it. Because I have a feeling that this will be the rest of the class. I don't know this one first, but I just guess.
Brenda wishes to find so that will determine what she needs to do and how she needs to do it. We are advising our CEO. She intends to what forms? Okay, there's a procedure that I can expect to be followed.
Isn't that his blueprint now?
That's what
Oh, that's when they filed it. That's the first one they filed it. What happened? Yeah, this is for someone who's filing it.
somebody's filing it.
Oh, that's not so bad.
There is a process from place from the county level to the
See, this is the partner of the process from the partner of the This is not past,
Yes. There's people on the phone. Neighbors who come from unresolved. And that last week,
So I mean, she filed with the
already
labor
went
board.
through the labor
Process.
So I do
That's when the rule has filed, when the rules trade, dispute.
I know last Thursday, it was the refer to the tribunal, like it's like the last meetings. As a result of this, just saying, how you advising?
So this day I do it. I am so funny.
No, before we leave, like, you can make up, you can take it, you know, council. Legal counsel.
No, he said he neutral to the situation in that he doesn't. But
but did you say J? That's F.
No.
Those are
No, they said it's set it aside if they know how to dismiss it then, or they come to an agreement, they can.
I agree with the applicant, it's coming with law. Thereby, according to rule 7, subsection something of the industrial relations to vary or set aside the direction of the right, requiring right to do something. So when they just put that decision following in the case, they probably say, okay, we need to do this, and we know what, and we need to do that, so. get that on the-
Government fine, and the case unless.
Now, there's details,
Yeah,
you
but
Given prior, I mean,
we're not gonna assume that part, because we're not affecting that. That's policy, one thing. Yeah,
Jeanette?
She could say,
Someone will be.
well, then me.
For 19 years.
Yeah.
Before she went there, hiding.
That's what you look like. You can tell me.
Yeah, because they all look alike. You can right now. They all look alike.
So let's see how brilliant y'all are. You ready? Y'all done? Y'all done?
Yeah, she's a collection.
What about y'all? Y'all done? Okay, good. Okay, so let's hear from Brenda's friends. Or Brenda's legal advisor.
Okay, we would encourage or advise Brenda to
First of all, escalate, because technically she only had a conversation with the HR manager. And so before, like, taking the matter externally, or trying to resolve the matter externally, to at least escalate to the CEO possibly, or the person that's over the company, to see if she can get some resolve there. And if not, then to take the matter to the labor board. And in doing so, she will report a trade dispute, completing this form, this lovely form here. Do you want us to go through the form?
Yeah, so,
Okay. A name of name and address of company, you insert ABC Company Limited, name and position of employer. You weren't certain whether or not.
that's fine, yeah, so you just tell her she'll have to put that person's name.
Right, most likely the HR head or the CEO, someone who will be the face of the
Right up
company.
here, exactly.
Name of the employee and trade union would be Brenda Wu. Name of persons on whom, on behalf of
Job
whom-
title,
Sorry, job title, manager corporate office. Name of persons on behalf of whom the report is made. Brenda Wu. The authority to act on behalf of the person desiring the dispute to be reported. Now, this particular portion, we're not certain of whether this should be the person who would represent it, if
well,
any.
actually, this is it, name a person on behalf of whom the report is made. So for example, let's just say, a firm may have prepared this, then the authority to act on behalf of the person who designed the dispute to be reported, the attorney would basically say, I was instructed by, Brenda Wu, for example, right? So they're just saying, if Brenda Wu is not completing the form herself, what authority do you have to complete this form on her behalf?
Oh, okay.
So the form contemplates, being completed by Brenda or someone acting on behalf of Brenda. So when you look at 3 and 4, you actually, those questions are kind of questions to a person who is acting on behalf of Brenda. Okay?
She was acting on her own.
If she's acting on her own, she wouldn't have to answer 3 and 4. She would have to answer 4. Okay? She definitely still have to answer 3 because she's still doing it on her own behalf. She's the name of person on behalf of whom the report is made, right? So she'd have to give a name at some point, right? So that 3 would be answered in any event. But together, 3 and 4 contemplate the form being the form being prepared by someone who's an agent of Brenda.
Okay. But that being said, I guess 4A would be the address of that agent. And 5, issue relevant to the dispute. We would speak to, or we would advise her to speak to the breach of the employment contract because she wasn't paid, she didn't receive payment for the month of April, and she didn't receive payment for her 2 weeks vacation that she was promised.
She's something else too she didn't get.
Note.
Exactly.
What
You
was
ain't
that?
give her notice?
But we were, it didn't say she was terminated.
She said she was allowed in the
It didn't
laws.
straight out say that. So we thought this was just unfair treatment, not necessarily dismissal.
Okay, fair enough. Good. So fair enough. They didn't say she was terminated. So let's just say she was. Let's assume she was terminated, right? What else would you add there?
If she was terminated, then it would have been wrongful dismissal because she didn't receive the notice, as well as, I think, unfair dismissal because of what was said about her, I guess, being.
That doesn't make it unfair
She
though.
wasn't
In the
treated fairly.
in the circumstances, that's unfortunate. Those circumstances, like what the lady said, was just unfortunate. That was just extra stuff. Because the reason why she was terminated is just that they have an issue with her. It's not necessary. It didn't give rise to unfair circumstances like things that you can't control. For example, like if you are pregnant or if you form a part of a trade union, that kind of stuff. You know, that's just it's just unfortunate that that is, it's as simple and as space as that, so that it's not as high as an unfair dismissal type claim,
Okay.
okay?
It's wrongful.
So you'd say wrongful.
Okay. Dismissal. And the actions taken for dealing with dispute under existing agreement. We assume that this was the actions that she had taken leading up to this.
Yeah,
How she had
so,
tried to resolve the issue before
right,
she got.
exactly, correct.
Okay, so based on what we were advised her to do, we would note here that she contacted the HR manager to inquire regarding salary, and vacation entitlement that she did not receive. And she would have escalated the matter to the CEO.
Yeah, had she done
And
that?
she didn't get any result.
And that's the thing, they say under existing agreement, so the question is there any agreement in place that requires there to be a step taken before you come to the Labor Department? And if one is in place, you would have to follow that procedure. If none is in place, I mean, she doesn't have to go to the CEO. She may have done that just because she thought it was prudent to do that. But if there's no agreement in place, she didn't have to do that. She could just put here, not applicable, you know? Because this one contemplates there having been an existing agreement regarding certain steps that need to be taken, okay? Then of course you date it and you sign it, okay? So good. So what other process is involved? I mean, she just completes the form. Do you advise on what else to expect?
We could expect.
She can notify in 14 days of when her conciliation hearing is
Well,
taken.
they don't, you know, it could be longer. So
Okay.
the tribunal, the department could take a little bit longer to notify, but she'd be notified by the tribunal, like you say.
Within 14 days.
Um,
Or it doesn't matter, there's no, up to 12 months and it's not something.
Well, you see it to 12 months.
No,
Okay.
File a dispute with the
Right.
Oh,
But
but
the
right.
but the board will get back to her as to what,
Next steps to take.
which is
Correct. With the reconciliation.
the conciliator. So
Mhm.
the next step would be they will send her a notice of the conciliation hearing, her and the employer, right?
Okay.
And in that notice, the details of the hearing would be contained. So the date, the time, and the place. So they'll know who they're going before, and so when they attend, they'll have a conciliation hearing. Okay, and what's the purpose of the conciliation hearing? So it's to see if there could be a resolution on the matters. Okay, good. So I see your point that it's not clear here that she was terminated. So I understand that you had an alternative thing. So if she wasn't terminated, you would advise her to go to labor board if she didn't get anything, you know, if the employer didn't say anything about, sorry, the CEO didn't say anything favorable to her about the 2 salaries that she was owing. And so in that instance, you wouldn't treat her as being dismissed yet. You would just say okay, all right, fine, good. Question 2, part 1. So Brenda's already gone to her advisor. Now, based on how question 2, part 1 is written, you have to assume that she was terminated, okay? Okay, so let's hear from you.
Okay. So question 2.1 requires us to prepare a memo to the CEO advising him of the procedure which you expect to be followed, because the process at the Department of Labor is still unresolved and is referred to the tribunal for determination. So
The process is unresolved or dispute?
the dispute was unresolved, sorry. The dispute was unresolved from the Department of Labor, who referred it to the tribunal for determination. So, we have to write a memo to Mr. John Paul, advising him of the procedure and what forms we can expect to receive to be completed. So based on that, I sketched a little memo here, so I won't go through the title and all the rest of it. As you are aware, Brenda Rue's trade dispute with the Department of Labor was unresolved and was referred by them on last Thursday to the Industrial Tribunal for determination. Based on this referral, we can expect to receive at least 4 forms for completion from the Industrial Tribunal. The first one is Form C, which is entitled Notice of Originating Application, which will notify us of Mrs. Wu's application to the Industrial Tribunal and and gives us 7 days to respond. No, sorry. Form C advises us that we have to enter to appear at a hearing.
Okay, so this is what I contemplated by this question. That you would receive documents from the tribunal. So these forms are online. So let's assume that you have access to these forms, and whatever forms the company has to complete, the company will complete. So when I talk about receiving, I mean documents from the tribunal itself regarding a dispute filed by Brenda.
Okay.
So in that case, what documents would the tribunal serve on the company as a result of Brenda's dispute?
Would they get a copy of Form A? I'm not sure. I thought they get Form C, letting them know the Form A exists, and they have 7 days to respond.
Yeah,
That's
but
what I
then,
was understanding.
so how would they get Form A?
I don't know. That's why.
Right, so that's what I was saying to y'all earlier. Along with when Form C is served, Form C is served together with Form A, right? So you get a notice that Form A was lodged, in addition to receiving a copy of Form A. Because you would need to know exactly, so you get Form C and Form A, so you need to see exactly what was filed.
Okay. But I didn't understand. Okay, but let's move on. I didn't understand that.
Let's read Form C, because I actually said it to you as well. Form C says, I enclose a copy of an originating application. You see? It starts with that. And the originating application is Form A. So by that alone, if you had read Form C, you would know that Form A must accompany Form C.
All right. Well, out of receiving Form C and Form A, the company can expect to receive Form D, or Form D is what we'll have to complete.
Yeah, so you would have access to these forms, they'd be online.
Okay.
So
we'll have
the
to complete
respondent
Form
completes
D.
the notice of appearance, right?
Right, to say whether or not we intend to resist the claim that Mrs. Wu has made or not. After which we'll have to file Form E, which will be our defense to her claim.
And you file
complete
that 14
form.
days after you file Form D, right? I told you that when I was reading it.
Depending on how the case proceeds, the Industrial Tribunal may require that we complete Form F if they need further details on the matter. And Form J
No, so Form F will be prepared by either the applicant or respondent. Just wait till you have to read the forms, right? So it starts off, I or we, the applicant / the respondent in this matter hereby applies to the tribunal. So you make an application to the tribunal, asking for the tribunal to order the other side to give you further better particulars. Now, the tribunal can send you an order directing you to give better particulars, is what you may want to say. The tribunal wouldn't send you necessarily a document like in this form. It may look like this, but how this form contemplates the applicant or the tribunal making the application for it. You see?
That'll be Form B.
Right. You see? Very good. So Form B is where the tribunal would request certain information.
Okay, I'll stop there.
Anything else? Anything else?
Form L is what agency company can use if they require more time. To respond or to prepare a defense.
Okay. Okay, good. All right. That seems clear, right? So let's look at Brenda Wu's claim in any event. So that part we all were talking about on the form, we could always all go to the trade dispute form, right? So when she's talking about the issues relevant to the dispute, assuming she was terminated, how would we list it? So she has two salaries outstanding, but one salary outstanding because we're still in May. So she's getting cheeky. She's like, well, I ain't get paid last month. Can I expect to receive the salary this month? Let's assume when she asks a question, the HR manager tell her, go home, right? So Brenda goes to the labor board and she completes this form. At that time, what would be her claim? How would we complete part 5 of this form? So we want what? Let's list it. What all owing to her? Because now, when we look at this, we look at the issue or dispute. And so the issues, to get the issue, we're trying to identify what duty was breached, right? So let's consider that. What was the duty and what was breached? Okay? So looking at the facts, what duty was breached?
So we already established wrongful dismissal.
Which salary? So that would be April's salary. What else? Okay. So let's say we come under the Employment Act, right? LEUI. No, LIE. Right? Plus pay for each year up to 48 weeks, right?
Yeah.
So this is a wrongful dismissal claim. Okay. Well, actually, we in the 11th year, because she started in January 2009. But we have to prorate the 11th year, because remember it says on a prorated basis. So she were to complete 10 years, so up to 10 years plus, and then we prorate the 11 years, so we in May. So you just have to divide that, right? And so we have the prorated period. That's a wrongful dismissal thing, right? Anything else?
Vacation.
Vacation. It's 2 weeks?
Yeah.
Anything else? That's it? Let's try and quantify this. Let's try and quantify a claim. Okay? So if they were to say to us, what's the dollar value? Right? Let's try and figure it out.
1,000 for April salary.
So 4,000 for April salary, and that's excluding the
National insurance.
National insurance, right?
Yeah. Minus
Right?
100 for national insurance.
that's already excluding
Oh,
it, right?
right. Okay.
Now let's do number 2. So number 2, let's do part A, the notice paid. Right? So we say for the notice period, we will deduct, because we know she's a manager, right? So she get 1 month's pay. So let's just assume like this is the end of May, and they terminate at the end of May, right? That means she should get May's pay too. So we also have to say May 2. So I'm changing the facts a bit, okay? So let's just say at its end of May, she didn't get paid for April, they didn't pay her May, they terminated at the end of May. So she's also entitled to salary in May. But at the end of May, she's supposed to receive 1 month's notice, right? So the 1 month's notice or pay in lieu of notice. So they didn't give her notice, so they have to pay in lieu of notice. So that first payment in lieu of notice is 4,000, right? So then for part B, when she gets for each year for up to 10 years, let's calculate that. So what we do, we add that 100 back to 4,000, right? So we have 4,100 times go on then, Brenda. Right? So now with this part, we have to prorate that month. So how do we prorate that? Which month are we in now?
The fifth month.
And then we can times that by her monthly salary, right? So how much is it?
1,708. I don't like the cents after that.
Oh, you rounded it
I
off.
rounded off.
Well, that's a good HR person. I hope you round up. Okay. Okay, so let's assume it's flat, right? So I say it's that. So let's add that up. Oh, that's right. So that's 45, right? 46,708, right? Yeah? That's it?
Yeah.
Plus, the April and May.
We didn't get vacation yet.
We ain't get there yet. Okay? So what's the answer here? 2 weeks. So let's do
Will
it.
be prorated?
I'm saying
Yeah,
that
they're
we got the
prorated.
1708 interest, and that's the, is it after vacation?
No, that's not paid.
No, we're going on
Yeah.
vacation this year.
Yeah.
Remember the 11th year?
11th year.
Oh, that's it, like,
Yeah.
Yeah.
Oh, okay.
Because you remember she started January
Okay.
2009. So January 2009, January 2019 is 10. So now she's in the 11th year. We have to prorate the 11th year.
Okay.
If you don't prorate the 11th year, she's missing something. What happened? Tell me.
Managers, isn't, supervisors, isn't up to 48 weeks?
Mm-hmm.
So it would be 48 before into the 48, right? The same way we did the two.
No. That just says that's the maximum you could get, right? Not the maximum. Okay. What that means is the maximum any employee could get would be, who's a manager, would be if that particular employee worked for 12 years. If you worked for less than 12 years, you get your 1 month's pay for each year that you worked. Essentially what that section is saying essentially the section is saying you get 1 month for each year you've worked, full stop.
Okay.
Now, we don't keep calculating that 1 month for every single year you worked. If you worked for more than 12 years, the maximum that we are willing to give anybody is 1 month for each year, up to 48 weeks. That's the cap.
Okay.
So if you worked for less than a year, if you work for less than 12 months, then you get your 1 month for the entire period you work, for the number of years you worked. If you work for more than 12 years, the most you could get is for the 12 years that you've worked. In her case, she only worked for 10 years. You see? Well, 10 years and 5 months. So our calculation is 4,100 times 10 years is the complete years, right? And then we have to take into consideration the 5 months that we're working with, right? So we have to prorate that monthly pay by the fraction of the year that she's worked. You follow? You sure?
I follow, but I still
Explain it
don't
to me
know.
then.
What is the 48 weeks? What is?
Okay, let's look at it this way. Forget any employee, right?
Uh-huh.
And let's look at our sticks again. Okay? Let's go to our sticks. Okay, so each stick represents a year,
Mm-hmm.
and it represents the year of your employment,
Mm-hmm.
right? Also, we know for managers, you get 1 month's pay, and we just treat 1 month as 4 weeks,
Mm-hmm.
right? So you get 1 month's pay for each stick, right? So 4 weeks, keep adding.
Oh, so the maximum you could get was 48
It's 48
weeks.
working.
I got it. I got it.
That's the limit.
Okay?
That's the limit.
So let's add. 4 plus 4 is 8, 12, 16, what? 20, 24, 28, 32, 36, 40, 40, okay, 48, right?
Yeah.
Good. So that's the maximum anyone can get.
Okay, got it.
If you work beyond that, it doesn't matter. The statute said up to 48 weeks. If you are under 48 weeks, you're good. You get compensation for all your years. Okay? But if you work beyond, you only get compensation for up to the 12 years you've worked.
But that's just the minimum.
Sorry?
But that would just be the minimum.
Yeah, under the statute represents the minimum. Your contract may give you a greater
little
note.
bit more,
Yeah,
yeah.
it may.
Mhm.
Or the common law may yield a better result. So you clear on it?
Yeah.
Okay, the vacation, the prorated vacation, she's got.
We didn't prorate vacation yet. We didn't get to vacation.
Oh, that's a salary for the.
This is
for
the wrongful
yeah.
dismissal claim.
Right.
So let's talk about the rationale behind this. So the wrongful dismissal claim, we have 3 things here. So it says you get 1 month's notice or 1 month's pay in lieu of notice. That's what we put here at A. So they terminated at the end of the month. They told her don't come next month. In fact, don't come ever again. So the Employment Act says, well, if you didn't allow her to work out a month, to pay her for a month. I remember we said that month you have to take out national insurance. So that's the $4,000 for that month. Now, you also get 1 month's basic pay for each year up to 48 weeks, right? So so for each year of service. So you could, so what we do is we added the $100 because you can't deduct the national insurance payment, and we multiply that by the number of years. Okay. But we know she started working which month?
January.
Which year?
2009.
Now, it's May 2019. So January 2009 to January 2019 is 10 years. So let's work on our complete years first. So what we did is we split the calculation. okay? So we took 4,100 times the complete 10 years. But we are aware that the statute says, and we could prorate the year, right? So for the additional year, because we're in 11th year, we can't give her the full 11 years. She's only been working for 5 months, right? So what we have to do is, and really, let me tell you, this is wrong. If we had given a notice, and this is it's arguable, if you give her a notice, she should have been working up to June, right?
Yeah. Yes, this is the end of May.
Right? That's essentially when she'd be working, we choose to pay her instead of her coming to work, we could treat that period as her having been working, which is a rationale for paying her national insurance, right? So right now, this should really be 6/12, where we could prorate it, okay? So we understand the rationale. So let's say 6/12, and this is the calculation. So that's how we prorate it for the 11th year, okay? Now we get to vacation. This was on vacation. There's still wrongful dismissal claims. So let's say vacation pay, we know it's 2 weeks. So how do we calculate that?
12,000 divided by 2.
You sure?
You take the annual
If you-
salary divided by the weekly rate, or you determine the weekly rate divided by 52. That's what I would do, sorry.
Yeah, because you would
Divided by
get.
52 to get the weekly rate, then times that by 2 weeks.
So let's do the 2 so we can see how it works out, right? So you say she should get
If she's paid monthly,
4,100 divided by 2, which would be 2,050. So what's your name?
Angela.
Angela says.
But I thought it was,
Carla says.
I thought for the year though, they have a pay
The
share.
41,000 divided by 52.
So we wouldn't have to.
Because the
prorate that
monthly
as well.
salary is already amortized. Some months you work 4 weeks, some months you work 5 weeks. So
Exactly.
it'll never be.
So let's work out.
But if you're paying
41.
monthly, you're paying the same regardless of whether it's 5 weeks or 4 weeks.
That's what I say, it's amortized, but when you, the calculations will differ.
So let's look.
Yeah,
4,100. 4,100 times 12 is.
Yeah.
4,100 times 12.
49,000.
49 to 49 to.
Yeah.
Mm-hmm.
Right, by 52. And then multiply.
Divided by 52.
Or you could divide it by 26, right?
Yeah.
$18.92, 31.
That's just how it is.
So what determines which one of these calculations you do?
And that's the thing. I mean,
How I understand it to be, if you're paying them for week's salary, then you should determine what
the
the weekly rate
and that's the
is.
thing. Because what some people do, they do the same thing you do. Employees would love that.
But
Okay,
she's
exactly.
but with the manager position, is it the month now? Not the week?
No.
Yeah.
This vacation pay.
It's accrued
Oh,
vacation.
Oh,
Yeah,
okay.
it's two.
Okay.
See, and that's the thing. When you look at it, you look at your units,
Yeah.
right? Your unit is weeks. It doesn't say half. It doesn't say your vacation is half a month's pay. You take vacation in terms of time, and that's 5 days, 5 days. So for her, this represents 2 weeks. So when I say it depends, like if you're an employee, I mean you're really gonna complain about their calculation, but in terms of what's right, and when you're calculating,
You have to calculate.
you have to
what a
calculate. You have to
week
get
is.
back to your unit, and to get from month to week, it is not right to take your monthly, because like she said, you have some months with five weeks, right? And that's the thing, which is so weird even about this calculation, because 4 weeks pay for each year you've been working. I mean, it doesn't really go, it should, 12 years is really, should be 52 weeks, if you think about it, right?
Right.
So, that's to me, this is what's weird about the calculation, right? Because you're taking a full month's pay, but you're still considering it by 4 weeks. But essentially, I would say, and we always argue that it's really taking into consideration your annual salary. That's you always wanted to come back to your annual, because, you know, they say you get 1 month's notice, right? So let's look at our monthly pay and just multiply that up to 12 years, okay? Because to do it otherwise, it just makes nonsense of the rationale behind the calculation. But when you're coming here and you're actually going to prorating and you getting back to certain units, you have to go back to your week. And to go back to your week, you have to consider the number of weeks. So we divided by 26 because we know that 52 divided by 2 is 26, but it also represents every 2 weeks as well. Okay? And so this is the exact calculation for the 2
So
weeks.
if our vacation was 4 weeks a year, could we use the monthly?
Sorry?
If a vacation was not 2 weeks but 4 weeks.
I'd say use the monthly. That'd be the easiest thing to do.
Right.
Now the thing is, you know,
You still have to stick with me.
and that's the thing. If you're getting back, and that's the
You
thing.
still have to stick with
And
me.
that's the weirdest thing about our calculations, right? Because really and truly, a vacation, it's 2 weeks, right? But it's kind of, you could look at it as half a month, but it's not really. And it really kind of really depends on the month. But at the end, but no, it actually doesn't, because it doesn't because your 2 weeks is your 2 weeks.
So some
No
months
matter
it'll be
which
2 and a
month
half,
you take,
and some months
no,
it'll
but
be
no
2.
matter what month you
That's
take,
true.
2
That's
weeks
true.
is just 2 weeks. That's just simply it.
Yeah, that's true.
It's just 2 weeks.
And 4 weeks vacation is just 4
It's
weeks.
just 4
But
weeks.
some months, 4 weeks
But
is
I'm
not a
telling you,
month.
people would make it just easier.
But
You'd have a
it's-
So
problem.
that's why.
You'd have a
Birthdays
problem
and
with your
our
employee
calendar days, so
if you
it's
give your
almost
employee
weekends, yeah.
only 4 weeks pay for vacation.
So like
You'd
you
have a
said,
problem,
stick with your
because it
unit.
would be short. No, but I'll tell you, to be on the safe side, if someone is working monthly for let's just say they have 4 weeks vacation, right? Just to be on the safe side, I'd say give the person a month's pay. But to be very pedantic about it, you should it's 4 weeks.
Be very
Pedantic, because
like that.
you could get yourself in a problem because you're fighting over a couple more
Pennies.
dollars.
Yeah.
Yeah.
And if you just want to stick to the rationale behind it, you could waste so much time when you could just, as a month, just give the person the month's pay.
But I mean, in most cases, when you hear vacation, you don't hear it in months. Oh, man, you get 2 months.
I
You hear
know.
man, you get 10 weeks or 5 weeks.
Right.
So you always.
Which is what I'm saying. I'm just saying though, practically speaking, you go give even if your employee works with you and they accrue up to what they call a month's pay. Everybody considers 4 weeks a month. They accrue up to a month's pay. And for that month, it may really be 4 weeks, right? And you pay them 4 weeks and you don't pay them their salary for the month. You'll have hell on your hands. You see? So I'm just talking about the human element in that part. Now, when you come into litigation or something, then you could be very a stickler. But 4 weeks is 4 weeks. You see? Okay? Good. So, if we had to quantify a claim, what's the total of it? So we have 4,000. Boy, drinks on Brenda.
Any drinks, man. Lobster.
That's the
$56,600.31.
7 before is what? 11?
11.
15, 16.
56, yeah.
Okay. So she carrying on a little bit, right? They just gotta pay her now. So that's why Brenda said, you know what, I'm letting this rest. this is how much this dispute is worth. So whether you call it 2 weeks or half a month, because I mean the difference isn't that huge, right? Whatever it is, you owe me at least $56,000.
Yeah.
Let's go to court.
Okay? So we good? Yeah? So explain to me the rationale, why we behind section 29, 1, B and C. The managerial one, and let's do it C.
I'm explaining
The rationale behind the calculation, because you asked me before, well, why 48? And
because the cap is 12 years. Transfer it right now. You get paid 4 weeks for each year that you work. A manager supervisor will be paid 4 weeks.
the AXA is 1 month. The AXA is 1 month's pay, right?
Okay, a month's pay.
Yeah, but for our calculations, how we break it down for us to understand what that's supposed to mean, we, in our minds, call it 4 weeks. Okay, but we know you must give that person a month's salary.
So whatever that month's pay is, not necessarily what 4 weeks.
No, the act doesn't say. The act doesn't. The act
say
says.
weeks at all.
The
It
act
says
says the
month.
pay is 1 month.
The weeks is for
The cap is the weeks.
Right.
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 So when we want to look at the cap, in order for us to appreciate how many years that work out to, we're gonna have to divide the 48 weeks by 4 weeks. You see? But our pay calculation is month. It's an anomaly. I agree with you. Like when you look at it, like what? Because you're working with months on one end, then you're telling me weeks. Why you just can't say up to a period of the maximum of 1 year's 12 years employment. You know what I mean? If they worded it that way, you wouldn't have to get into the month and the weeks. But that's the only way to break it down, so that you could explain the rationale behind the calculation. Okay? You good? You okay? Yeah? Alright. So what's the difference between the calculation for managerial and non-managerial? It's just kind of almost split in half, right? So they get a shorter notice period, and then it's a shorter period of service.
Right.
Yeah. Mm-hmm. Okay? Actually, I shouldn't say shorter period of service. I was wrong.
No.
It's still the same period of service. It's just a smaller sum that you would get for the same period. So the equivalent is 6 months' salary, but it's 6 months' salary having worked for 12 years. Yeah. So I was wrong when I said a shorter period. That was wrong. Okay. So that's it for tonight. We good?
Yeah, this was awesome.
Yeah? Module 3. This is module 3. Yeah, module 3. Sorry, not module 3. Yeah. You all can module 3. Next class, please. Yes, ma'am. Good night.
Good night.
Good night.
Good night.
Good night. Good night. Good night.
It's the tree of me. That was a knee jerk.
I read them, I understand them in theory, but could you give me an example, like using the stair thesis and the ratio
Okay.
TC,
Then
whatever.
die. Right. Okay. So they actually complement each other, right?
Mm-hmm.
So the ratio is the justification for the decision. So if I make a determination in an employment matter, right? Let's just say I determined that you were properly summarily dismissed,
Okay.
and I say this because anyone who was caught stealing from the company
Right.
has basically breached a fundamental term of the contract of the employment, and I say why.
Mm-hmm. Okay.
So that rationale, right? When I explain why what you did
Mm-hmm.
amounts to something that's a fundamental breach of the contract of employment, and therefore justifying it being summarily a ground for summary dismissal,
Okay.
that gives rise
Which
to
is
a
immediate
ratio in
dismissal.
my
That's
case.
what summary dismissal is. Immediate.
No, it's like dismissal with cause,
Mhm.
and I can dismiss you. I can dismiss you on the spot without an investigation being
Okay.
done, depending on the circumstances. Now, if I caught you doing it, I don't have to conduct an investigation.
Okay.
But if I have issues, if we think you did it, we have to investigate to be sure that you, in fact, did what we thought you did.
Okay.
So summary, it's
We caught
in the
you in
sense
the
that,
act.
yeah, we caught you in that, right? No, not just we caught you in that, but it's also, your employment comes immediate, and because we think that you breach a fundamental term of the contract of the employment, right?
Okay.
So I don't have to give you notice,
Okay.
right? But I have to prove summary dismissal. I have to prove the grounds for summary dismissal.
Okay.
So I have to prove that you did what I say you did to justify me not giving you notice of
Got
your
you.
dismissal, right? Now, once the court makes a determination on this issue of summary dismissal, what gave
Mhm.
rise to it, what substantiates a summary dismissal claim, right? That forms the ratio of that decision, because the court had regard to the circumstances and made a decision on this particular issue.
Okay.
That's the ratio.
Right.
So when I look at the ratio in that case, when I'm in another case and I'm looking for someone to define dishonest, and looking for a definition of dishonesty or something, I go back to, I look at the decision that was made, but I have to go back into how the decision was made. It's almost like, what's the rationale of the decision? I rely on that rationale
Mhm.
to support a position in another case.
Okay.
So although this case, everything about this case represents the decision,
Mm-hmm.
I have to zero in on the exact decision that was made by the court, the rationale and everything behind it, and that's my ratio. That's the justification in this case. This is
Okay.
the court's decision on the issue at hand.
Okay.
So the
Gotcha.
ratio in that case is what makes a case possibly binding on another court. It's not, okay, not what makes it binding, because the fact that the court is a higher court makes it binding, but what makes a decision relevant in another case,
I got you. So
right?
how does- uh-huh.
So I can't rely on a ratio in a case that is not relevant
Is
in my
this-
case.
Is this just an abbreviation of the?
Ratio this and that.
Okay.
Yeah. Did that help?
It did, but I mean now connecting
Now,
it to
STEM
this.
DCCs. So this is the thing is when the court makes a determination, and it's a superior court, for example,
Mm-hmm.
the decision is final.
Okay.
So the decision of the court is final, and then by virtue of that, the court making a decision regarding the issues that the court had to determine, right?
Mhm.
So applying the law to those facts of the case, the decision that the court makes becomes a precedent. So by
Okay.
virtue of the pronouncement of the decision stands. It's
Okay.
a precedent. It comes to an end. That matter is determined.
Okay,
right? So that principle just basically says let the decision stand. That's a final decision until it's appealed.
okay. So this,
So that gives rise to it being a precedent. And it's a precedent until it's appealed or overturned by another
Okay.
court.
okay, so using the same example that you used about, the summary dismissal, right? And letting the decision stand.
So once the court makes a ruling in that case, it is, as far as that is concerned, that it's binding. I mean, it's binding between the parties, right?
And
It's the final decision.
and it's binding on all the lower courts as well, right?
Right. This is binding on the lower courts. It's a final decision until that decision is appealed and overturned.
Okay,
So this is the basis upon which something becomes a precedent.
looking at all of the facts in that case, the basis.
Once the court makes a decision, that's a final decision. That's the basis upon which it's final, it's a precedent, and it can be used in other cases.
Okay,
So it's a fundamental of a decision. It's just the basis upon which is the basis upon which a ruling or decision by a court becomes a precedent.
okay. And when we say basis, we're talking about
The fundamental, the justification, the foundation.
the judge's justification in this.
No, I'm saying this
Decision?
principle, the
Uh-huh.
principle itself. After the court considers everything, this principle of stare decisis is the foundation upon which a decision by a court becomes a precedent. Because the rationale is the decision stands.
Okay.
This is the decision of the court, and until this decision is no longer a decision of the court based on
I
an
got
appeal
you.
court says, no, we don't like this decision, etc. Until that happens,
This is what it
precedent.
is.
Yeah, and this principle attaches to every judgment of a court until it is
So we make the
Until it's
decision,
overruled.
it stands, and it becomes a precedent
by
that
virtue of,
binds
or,
lower
or,
courts.
right, or it could be persuasive.
Okay,
Yeah,
I get it now.
yeah, okay, good.
I was very simple, like this little.
No, don't seem at all.
I
You seem
just
inquisitive.
To me, I just like this, it makes sense. If it
Yeah,
doesn't flow, to me,
yeah.
I get it, but it was choppy, that's why I actually give me a practical example, so I
Okay.
can now look at, okay, I can look at summary dismissal now, and that
Uh-huh.
example you gave and make it make sense.
Okay,
Thank you.
good, no problem at all.